Thank you. Such a pleasure to be here. And yes, so today I'll talk a little bit about the class action landscape against OpenAI primarily, but also I'll discuss these two important cases that you may have heard of because they were in the media a lot that came down in June. One was against the AI company Anthropic, and then the other one was against Meta. By no means, this is by no means an exhaustive view of class actions. I think there's over, if I'm not mistaken, over 60 class actions against AI companies, but this hopefully will be a representative view that gives you a basic understanding of what's going on in terms of the class action landscape in the US. Next slide, please. Okay, so just briefly, I will introduce who we are. I represent the Authors Guild, which was founded in 1912, and it is the oldest and largest U.S. organization for professional writers. Currently, we have over 17,000 active members, represent novelists, nonfiction writers, journalists, poets, translators, self-published writers. We have writers that have won every major award, I believe, except the Nobel Prize in Literature, but I could be wrong. And also a lot of writers who write for magazines and newspapers. Our mission is to defend free expression and protect IP rights. We advocate for fair contracts and sustainable living wages for writers and try to build a community, professional community that writers can rely on in their professional lives. Next slide, please. So as I said, today what we'll cover, I'll start by covering the class action format in the US very generally, and then I will devote a lot of my time talking about our case, which is Authors Guild v. OpenAI and Microsoft, which was filed in the Southern District of New York in September 2023. And I say I'll cover that case, but as you'll see, it's a case that has been consolidated into 12 other, with 11 other class action lawsuits against OpenAI. And then quickly, I'll go over Bartz v. Anthropic, which was a case out of the Northern District of California. And I forgot to put Kadri v. Meta, which is another case that came out of the Northern District within a week of Bartz v. Anthropic. And they're both really important and interesting decisions that show the direction of judicial thinking on AI and copyright issues in the United States. Next slide, please. So to start, class actions in the United States. I did a little bit of research into class actions in Austria, and I understand that there's an Austrian version of class actions, and then there's also may have been superseded now by an EU version of class actions. But as in my experience, as I talk to our friends from across the Atlantic in the UK and the EU, I always find that they're very curious about class actions. And I'm by no means a class action expert or a lawyer. I've just been involved in our particular class action and a couple of others that we have ongoing. So a class action is a legal procedure that allows one or more plaintiff to file and prosecute a lawsuit on behalf of a larger group that has suffered similar injuries. The purpose of a class action is to ensure judicial economy. It allows plaintiffs with small claims to seek justice when costs would otherwise outweigh their potential recovery. Typical cases are consumer protection, employment, securities, and antitrust. In the copyright area, class actions are very rare, which is why when I talk about the Anthropic case, I'll emphasize this point, why it's such a pivotal and monumental decision for case for class action copyright suits, particularly against AI companies. And against AI companies, class actions make sense because of the numerosity of the plaintiffs and authors, illustrators, other creatives whose works have been used without their consent or compensation. So one of the most important and critical steps in a class action is where the court must officially certify the lawsuit as a class action. So a plaintiff can file a class action on behalf of similar situated parties, but it doesn't actually become a class action until the court determines that there is that the purported class, that the supposed class meets Rule 23 of the Federal Rules of Civil Procedure, and these are the 4 requirements that a class has to meet before a judge can certify it. And as I said, so far, of all the class actions against AI companies that are going on, the only one where we have reached the stage is Bart's v. Anthropic, which I will talk about. Class actions do have a binding effect on all class members who do not explicitly opt out of the lawsuit, if they have the right to do so. Right now, as I said, most of the AI lawsuits are structured as class action because of the numerosity of the plaintiffs, and I talked about Bart. So next, we can go to the next slide, please. All right, so just a little bit of a history of this case, Authors Guild v. OpenAI and Microsoft. We're a plaintiff in this case, and as I said, we filed this case back in September 2023, still in the fairly early stages of the AI boom. You know, ChatGPT, I believe, came out late 2022, ChatGPT 3.5, the consumer version came out in late 2022 or early 2023. And so we filed this suit, you know, pretty quickly in the U.S. District for the Southern District of New York. It has 17 prominent fiction authors on behalf. Initially, when the case was filed in September, it was structured as a lawsuit for the infringement of fiction books and only covered the class. The purported class was fiction authors. Parallel lawsuit was filed in the same district court to represent nonfiction authors, and both cases were consolidated together and also amended to include Microsoft as a defendant, and I'll talk about why Microsoft was added as a defendant. Allegations included direct copyright infringement, vicarious copyright infringement, and contributory copyright infringement. Importantly, in April of this year, this case was merged, consolidated with, as I said, 11 other pending class action lawsuits, because in the interim, when we filed the case in September 2023 and late 2024, there were a dozen cases in the same district against OpenAI, more or less making the same allegations. So the court consolidated them into one action and assigned different judges. Primarily, there is a author track, which is all of the author lawsuits. We can go to the next slide now. Yeah, so there's the author. All of these are the author class action lawsuits. All of these were class actions that plaintiffs brought on behalf of the author class. And we can go to the next slide. And then we have these news journalism cases, the New York Times versus OpenAI case, which got a lot of press coverage. This was not a class action. This is the only exception. But then, there are these others who were that are also class actions. So right now there's essentially two tracks. There's the author class actions with all of the author plaintiffs, and then the news and journalism one. There's slight nuances, but more or less the claims are the same, which I will talk about. The current caption, the current formulation of this litigation is, I put it in the title of the slide. It's in re OpenAI in copyright infringement litigation, and it's still in the Southern District. We can go on to the next slide. All right, so because I was involved in the author suits, I will talk about the author complaints, our complaint that we filed initially, and then also when the cases were consolidated, we filed a consolidated class action complaint with some changes to the claims that we were making, or elaborations, so to speak, to the claim. So in our complaint, the first count, the allegation was direct copyright infringement in violation of Section 17 of the Section 17 U.S. Code 501. This was against OpenAI and Microsoft, and the key allegation there was both defendants reproduced copyrighted works from shadow libraries like Library Genesis to create training data sets. Shadow libraries are, some people call them shadow libraries, but they're open and notorious pirate sites. Library Genesis is one that has been around for a long time. Z Library is another one that was taken down with the assistance of, there was a criminal copyright complaint referral that we assisted the FBI and the Department of Justice in. And so the second count is vicarious copyright infringement, which is against Microsoft, OpenAI, and here we are naming Microsoft as a direct infringer along with OpenAI on the grounds that these entities had the right and ability to control the infringing conduct via the corporate structure and the computing infrastructure, and they obtained a direct financial interest from it. And count 3 is contributory copyright infringement, also Microsoft and all OpenAI entities, on the grounds that Microsoft materially contributed by providing billions in funding and designing the bespoke supercomputing system specifically for OpenAI. And the allegation there is they knew that, or had reason to know that OpenAI was using scraped data. So let's move on to the next slide. Direct copyright infringement. The core legal theory here is that plaintiffs are alleging that both OpenAI and Microsoft violated their exclusive rights under the Copyright Act, specifically the right to reproduce copyrighted works by building the models on stolen books. There's 2 stages to the copyright infringement claim. One is the input training stage, where the allegation is to build models like GPT-4, defendants reproduced. At the time when we made the allegation, our assumption was that it would be hundreds of thousands of copyrighted books from these illegal pirate sites like Library Genesis. But as I'll talk a little bit about when I talk about the Anthropic lawsuit, the volume of books we are coming to know that was used to train large language models is much larger. And the claim rests on the fact that the technical process of training a large language model involves copying the data into the machine and running algorithms on it, which essentially causes the model to memorize the copyrighted data. Let's go on to the next slide. The second stage is the output allegation, which is the evidence of infringement. In our complaint, we provided different sorts of examples of when prompted, the OpenAI models were able to reproduce text from the works in question in the allegations, and also provide detailed summaries and including outlines and structures and even some text for hypothetical sequels of the allegedly infringed works, and that the latter part is in in the U.S. copyright scheme, there are 6 exclusive rights that a copyright owner has, including the right to create derivative works. I expect and believe that Austrian copyright law has similar analogs, but the generation of summaries or rather the generation of hypothetical sequels or outlines based on works that were ingested, that was a purported violation of the right to create derivative works, one of the exclusive rights. And the copying itself to train to run the algorithms on was a violation of the right of reproduction. That's our allegation. We can go on to the next slide. Next, okay, there we go. So I'm sure that many of the attendees there have at least encountered this concept of fair use. In European law, it's fair dealing. It's more of a statutory or code type formulation, but in the U.S., it is a fair use is a judicial doctrine. Well, it's in the Copyright Act and in Section 107 of the Copyright Act, but its interpretation is done by judges, and it's what we call a rule of reason, which means that there's flexibility in terms of how the judge applies the factors. And there are 4 factors that judges use to analyze whether a use is fair use. And fair use is basically it's a forbearance to someone that uses a copyrighted work without the permission of the copyright owner. If the use meets these 4 factors, which in theory advance the public policy of copyright law, which exists in this dual purpose or tension between giving the rights owner a limited monopoly on their creations while advancing a public benefit from the works. So the 4 factors that judges look at are number 1 is the purpose and character of the use. What was the use for? Is the use commercial or nonprofit? And there is a second part to that question that was a query that was developed during the court cases on fair use, which is, does the use transform the original by adding any new meaning, message, or purpose? Purely exploitative uses that substitute for the original weigh against the first factor of fair use. The second factor that courts look at is the nature of the copyrighted work. Use of highly created works, novels, artworks, photographs generally weigh against fair use finding because copyright law does not protect ideas, truth, facts. So the distinction, and I'll talk a little bit about it. It came up in the OpenAI cases. The distinction is that between a news article versus a short story, a higher degree of protection because the expression is it's not based on publicly available information. It's not factual. So copyright law does not protect facts and ideas. The third factor that courts look at is the amount and substantiality of the use. How much of the original work was taken, quantitatively and qualitatively. So it's a lot of times people, when they ask questions about fair use, they have this notion that there is a kind of threshold or percentage that if they stay under, that they can have the benefits of fair use. So, taking less than 25% or 10%, and that's not true. It's not all about the quantity. So you can take one line from a song and still have it be infringing if it takes the heart of the work. So, the example that I always give is if you, in the Beatles song, if you're copying Let It Be, that kind of goes to the heart of the work. But if you're copying 5 lines from a 100,000-word novel for purposes of critical analysis or commentary, then it's likely fair use. And finally, the fourth factor that courts look into, and this is turning out to be one of the most important factors, and there's a lot of debate going on around this factor, is the effect on the market. And in parentheses, I will say effect on the potential market for the work too. Does the use substitute for the original or harm actual or potential markets? It can include harm to licensing markets, like markets for derivative works, and markets that may come into existence. And in the AI context, there is an ongoing conversation right now as to whether this harm to the market looks at the substitution of an individual work that is being displaced, or it can be conceived as an aggregate harm to the market for entire, the entire book sector. So we can go on to the next slide. So I talked about transformative a little bit. It uses transformative when it adds new expression, meaning, or message. And courts must balance transformation along with other factors, especially market harm. And the key takeaways for the AI context is that training on copyrighted books to produce outputs that substitute for human works likely harms markets. The use of entire works, especially creative works, cuts against fair use because you're not just using like a part of the book. When you're training something, you're using the entire text and millions of such texts. So the third factor, outputs that imitates an author's style or create market substitutes, they're not meaningfully transformative. They're just substituting the original. And even if the training use is considered to be transformative in the sense that it adds new meaning or message or purpose, the inquiry doesn't stop at whether the use is transformative. Indeed, the courts are going to look at whether the extent to which the use harms the potential market for the work. I think we can go on to the next slide now. So the case also has these secondary liability claims, as I went over them in my earlier slide. This is just an elaboration of that. I'll just let you guys take a look at that. All right, we can go on to the next slide. We can go on to the next slide. So this is where the lawsuits currently are. In October, OpenAI filed a motion to dismiss, and I'm specifically just talking about the author lawsuits that we are involved in. As I said, the cases have been consolidated, but there's different there's different things going on in the author track versus the news, the news cases, and so it's a little complicated. So all of this is about the author lawsuits that we were involved in. So in October, the court denied OpenAI's bid to dismiss the class plaintiffs' copyright infringement claims regarding outputs. As I mentioned, one of the claims that the class plaintiffs are making is that the outputs of summaries and potential sequels, those violate their exclusive rights. So those are infringing. And there's also a question on whether successive GPT models will be included in the complaints. So as you can see, they were rejected. And then one of the things that sort of changed between the time that we initially filed the lawsuit in September 2023 and the consolidated complaints and the consolidations is the discovery that happened in some of the other cases, and the factual insights those cases elicited that the lawyers, the attorneys then could use in our case. And one of them was the fact that AI companies had been using Library Genesis and Z Library. So the consolidated complaint takes that into account and hones in on that. We can go on to the next slide. I'm just going to talk about this one ruling from October 2025 because it's really important. It was on OpenAI's motion to dismiss, and I apologize if I'm not explaining some of the procedural stages of American litigation. I just realized that. So a motion to dismiss, it's in U.S. lawsuits, there's a stage called summary judgment, which is when a lawsuit starts with the parties, the plaintiffs making their factual allegations, the defendants responding to that, and then it proceeds with the different motions until one party or both can make what's called a motion for summary judgment, which is also called a judgment as a matter of law, which is essentially saying to the court, we don't need to go to trial. Judge, have all of the facts you need right now to decide this case as a matter of law, and so that's where we were. OpenAI was arguing that the plaintiffs didn't infringing outputs, and there was no need to go to trial. It was apparent at this stage that they didn't have a claim, and the judge denied that, which was very interesting because the judge relied on the allegations made in our complaint about the outputs, what I talked about, the summaries and the sequels. So one example would be, during the complaint stage, the lawyers, we were able to prompt the GPT models to say, write me a sequel, a hypothetical sequel to, one of the Game of Thrones books that's different from the actual sequel, and it was able to provide a fairly thorough outline with character sketches, world building, and the like. And that was one of the allegations. Initially, when we had filed the complaint in September 2023, we were using those examples as plausible, to show the plausibility that the models had ingested the works. And now in the consolidated complaint, those examples also show that the output, whatever the models are putting out, is also violating the author's rights by creating potentially derivative works. And the judge said that there was enough of a factual question here for this to move forward, that whether or not these outputs were infringing of the copyright owner's work. So and then, I was talking about there's the distinction between the New York Times case, because in this case, the works were highly creative works of, novels and the like, not newspaper articles. I think we can go on to the next slide. So Anthropic and Meta, these were two cases. So the class action situation in the U.S., like I said, we filed our case in September 2023 in the Southern District of New York. Around the same time, fall of 2023 was a very active time in terms of filings, and there were several cases also filed in the Northern District of California in San Francisco, and some of the cases were there was a stage at which the lawyers were trying to move all of including our case down to California, and that didn't happen. The Southern District retained its cases, and the Northern District has been litigating its cases. So there were two cases. One of them, two class action cases. One of them was Kadri v. Meta, and another one was called Bartz v. Anthropic. Against Meta and Anthropic that were working their way through in the court in Northern California. They were assigned to two different judges, and the rulings came out within a week of each other. And by the rulings, I mean that neither of the cases went to trial. They were decided on summary judgment, and class was certified in only one of the cases, the Bartz v. Anthropic case. In the Meta case, the class was not certified, and the judgment only applies to the plaintiffs, the named plaintiffs. So it's been a very exciting time, as you can imagine, in this field in the U.S. There's a lot of we're actually see judicial thinking taking shape, as we speak, as we discuss these issues. And the two cases really could not have been, more different in some ways, even though on their face they both ruled in favor of the AI companies on the fair use issues. But that's only a sort of superficial similarity, as I will talk about a little bit more. Bartz v. Anthropic, I think that was the first case that was decided. I get confused. The same week. And, the judges have their offices a few doors down from each other. But Bart's was very interesting because here the judge basically sliced the claim into two, where he said that training on copyrighted works was highly transformative use, and it was a fair use. He said that on summary judgment, said that there was no reason for him to take this to trial. However, in the lead up, in the discovery, we found out was that Anthropic had downloaded 7.5 million books from Library Genesis, another library mirror called Pilimi, and to build what they were calling a central library. And the idea was that they would have all of this. I think in one of the earlier orders, the court cited one of the developers saying they wanted every book ever written and the like. And the judge found that doing that was copyright infringement. There's another interesting wrinkle in this case and initially that's how Anthropic was amassing the books, but at some point they became concerned about liability, so they changed their tactic and they they acquired physical copies of books and scanned them for training purposes. And so there were these two questions in the Bart's case was, well, I mean, is downloading can downloading be fair use, or is scanning for the purpose of training, is that fair use? And those were the downloading question was gonna go to trial for basically the amount of damages that Anthropic owed the plaintiffs. The judge sliced the purpose of why Anthropic was downloading into two separate acts. So the act of downloading became a separate act of infringement, which Anthropic was liable for, and the training became another act of infringement. So very interesting. I mean, it does kind of like create this paradox. Well, if you're not getting books through legal channels by licensing, then how do you circumvent or evade this infringement liability? And that's very much like a live question. So like I said, we're right now, so the judge had set a trial date for December, but the parties were able to settle, I believe in sort of September, and then the settlement was pre-approved in October 2025. We are currently in the settlement stage in the sense that the authors who are class members are filing claims, the authors and publishers. The Authors Guild has been really involved in helping those authors file their claims. There are 465,000 books in the class. Initially, as I said, there were 7.5 million books that were downloaded, but after the removal of duplicates and non-English language books, and the judge also required that any book that was eligible for a payout must have a copyright registration before Anthropic's downloads, which happened in 2021 and 2022, and the registration had to have been acquired within 5 years of publication. I don't know if Austria has a registration regime, but in the US, the Copyright Office administers copyright. And while it's not a requirement to register, you need to have a valid registration to bring a lawsuit for infringement, for instance. And if you register within 3 months of publication, you get added benefits like statutory damages and attorney's fees. So, but also the judge used registration as kind of a parameter to add certainty to the class. And he also required that the books that were included in the class, they should have an ISBN number or an ASIN number. The settlement that was agreed on, I'm sure you guys have heard because it's the largest copyright settlement, at least in the United States, is $1.5 billion. And that comes out to around $3,000 per book, which would be split between the rights holders. If there's a publisher, the publisher and author will likely split 50-50, but there's other complicated mechanics of the settlement that I don't want to go into right now and use our time. So with that, let's move on to the next slide. So the second case that I was talking about was Kadri v. Meta, and in that case also the judge gave Meta a summary judgment and found that and this was a summary judgment. This was a judgment only only specific to the 13 named plaintiffs and their books, and the judge found that it was fair use. But that's just, again, that's just kind of a superficial answer to a very complicated question. So I'm going to go into that. Like I said, it was not a class action. Most importantly, both throughout the hearing process and even in the actual written opinion, the dicta of what the judge said is extremely significant, because the judge essentially comes out and says, I don't think this is transformative. I'm still, I don't think this technology is transformative on the whole, but you particular plaintiffs have not given me the evidence that I need to rule that right now. And basically saying, this case, like you should have developed a record differently, and almost making it a procedural, almost saying that he was ruling on kind of procedural grounds. But the judge did say that, as I was talking about, the the harm to the market is the single most important element, which again favors the rights holder's view, because the argument is that you can't build technologies on copyrighted works that then are able to produce competing works. And as I was talking about earlier, there's this question, this debate, open debate right now over how should courts conceive of the market harm? Is it the substitution of one allegedly fair use work for the original, or is it a broader aggregate impact on the value of all of those works? And the judge in this case seem to have been favoring the latter, which is also a perspective that was taken by the U.S. Copyright Office in their very important fair use report. The U.S. Copyright Office has been doing a study and for a couple of years on AI. Unfortunately, we're in a political environment right now where there's a shakeup at the Copyright Office. The register was fired. But the fair use report is the most important one, and the Copyright Office delved significantly in this question of market harm and how to conceive it. With that said, we can move on to the next slide. Thank you slide. I guess I got done with 6 minutes to spare.
So thank you very much for your talk, Umair.
My pleasure.